DM, Andrea Rayinger versus Ronald Rayinger, Attorney Redmond for Plaintiff.
Good morning to everyone. This is the time and place set for the trial in this matter. I want to go through just a little bit of, if you want some instructions in this particular point. Obviously, even though this is being handled by Zoom, recognize and understand this is a court proceeding and you must conduct yourself as if you were personally in court. I will say at this particular point, I note that the plaintiff is at a table. I don't know about you, sir, but I'm just saying at this point, find a place that you can, again, get good internet connection, stay there, don't wander around. It's disruptive and annoying, so don't do so. I will say that everyone will have an opportunity to speak multiple times, so do not interrupt each other. Don't interrupt any witnesses. And unless you have a valid legal objection, which you should make at that time, but do not interrupt the witnesses, the attorney, or I will tell you, do not interrupt me as well. Also, do not make any comments when somebody else is testifying. Again, you'll have an opportunity to respond. If, in fact, anyone should engage in any offensive conduct that interrupts the court proceedings, they can be held in contempt of court and you can go to jail. So I'm letting everybody know that up front. Court proceedings are often an emotional situation, and sometimes you get emotional. If that happens, take a moment, compose yourself. If you need, you can say at any point, you can say you need a 5-minute break or something. We can go off the record for 5 minutes, take a recess, have a chance to calm down and come back. So with that, we're ready to proceed. Ms. Redmond, are you ready to proceed?
Good morning. Yes, I am.
Okay. And Mr. Renninger, are you ready to proceed?
Yes, Your Honor.
Okay. Ms. Redmond, do you wish to make an opening statement or proceed to prove?
I would like to make a brief opening statement, Your Honor.
Okay.
Good morning, and thank you again. Ms. Ranger and Mr. Ranger were married in May of 2012, and they share 2 children in common, Lucy, age 11, and Oliver, age 8. Mr. Ranger's daughter, Cherry, lived with the parties while they were together and continues to live with Ms. Ranger today. Ms. Ranger is her legal guardian. As we shall hear in testimony today, Mr. and Mrs. Ranger separated in March of 2023, and Mr. Ranger has had virtually no contact with the children since then and has provided no financial support. Child support, child custody, parenting time, property division remain in dispute today. Ms. Ranger is requesting that Mr. Ranger's parenting time remain suspended until the completion of his criminal sentencing, currently pending a new trial date, that she's awarded sole legal and physical custody of the children. She's requesting that debts that were incurred during the marriage by Mr. Ranger without her knowledge or consent be assumed by Mr. Ranger, and that she's awarded the house that she and the children live in, along with the responsibility of making mortgage payments, maintaining upkeep, and paying utilities. She asks that personal property be divided equitably and that her former surname is restored. And thank you, Your Honor. And with that, I'm ready to move on to proofs.
Okay, thank you. Mr. Renninger, you have an opportunity now to make an opening statement, or you can reserve the opening statement, or you can waive your opening statement. Would you like to make an opening statement?
I'd like to reserve it.
Okay. Okay, with that, Ms. Redmond, you can call your witness.
I would like to call my first witness, plaintiff, Ms. Andrea Ranger.
Okay, go ahead, Ms. Redmond, when you're ready.
Thank you. Good morning, Andrea. So, Andrea, who currently lives in your household?
Me, Lucille, Oliver, and Cherry.
Okay, Ms. Renninger, just to let you know, it's a little bit hollow sounding there. So if you would speak up, because I will tell you, you can be saying whatever you want. If I don't hear it, it's not evidence. So if I can't hear it, it doesn't do you any good to say it.
Okay.
Okay. We'll try one more time, see if it's a little bit better. So who currently lives in your household?
Me, Lucille, Oliver, and Cherry.
And did Mr. Ranger ever live with you and the children in that household?
Yes.
And does he currently live with you and the children in that household?
No.
So when did you two separate?
March 15th of 2023.
And what caused you two to separate?
there was a domestic dispute and he was arrested.
And was CPS contacted following that dispute?
Yes,
And was a safety plan ever put in place regarding Oliver and Lucille?
yes,
And after that safety plan was put into place, did Mr. Ranger ever seek parenting time with the children?
not legally, no.
And did you ever allow him to have parenting time with the children?
I attempted to one time,
And when was that?
April 4th of 2023.
And what happened during that parenting time? How did he exercise it?
His sister picked them up to take him to ice cream, and they were with him for about 45 minutes.
And is that the last time that Mr. Ranger has seen the children?
Yes,
And has he sought parenting time in compliance with the CPS safety plan since then?
no,
So from your own observations, how would you describe the children's bond with Mr. Ranger?
non-existent.
And how would you describe your bond with the children?
Very well, very good.
And what sort of things do you do to strengthen that bond?
Well, we have family movie nights and family game nights. We do their homework after school every day. We go to the same school and just spend time together, do things around the house.
And I'm just going to remind to speak up just so that yeah. So do you believe it's important for children to have a bond with their parents?
Yes,
And do you believe it's important for that bond to be safe and healthy?
yes,
And who is the primary caregiver of your children currently, day in and day out?
me,
And do you take the kids to school?
yes,
And do you take them to medical appointments?
yes,
And do you take them to extracurricular activities?
yes,
And do you take them to friends' house for play dates?
yes,
And did the children always attend in-person schooling like they do now?
no.
When did they start in-person schooling?
April 25th of 2023.
And were they homeschooled before then?
Yes.
And why was it that they were homeschooled?
Mainly because of schedules or because it was just more convenient.
And did you want the kids to be homeschooled at that time?
No,
And who taught the children when they were homeschooled?
when we did it, it was me.
And did you do this while you were also working at the time?
Yes,
Okay. And did the kids have any other interaction with other children their age when they were getting homeschooled?
no,
And did Mr. Ranger participate in homeschooling at all?
no,
And did he ever express to you that he wanted the children to be homeschooled?
yes.
Did he ever express why?
It was more convenient for him.
And how have the kids, from your observations, reacted to starting in-person school?
They've adapted very, very well.
And in your opinion, is it in the best interest of the kids to remain in in-person school or to be homeschooled?
In-person school, for sure.
And why is that?
They're doing really well. They have a lot of friends. They're excelling in all of their end steps and all of their testing. They just seem happier, like they're truly enjoying it.
Okay. And when you and Mr. Ranger lived together, who was the primary caregiver of the children then?
Me,
Okay. And did he ever take the children to medical appointments?
no,
Did he ever take them to extracurricular activities?
no,
Did Mr. Ranger ever drink alcohol when you two were together?
yes,
And did he ever drink it excessively?
yes,
Did his mood or behavior ever change when he drank alcohol?
yes.
How would it change if you don't mind describing to me in the court?
He became very irritable, more violent when he was angry. Just a nuisance, broke things in the house.
And did he ever drink excessively when the children were around or in the house?
Yes,
Were you ever worried for the kids' safety or care when he drank?
for their care, yes.
And why is that, if you don't mind explaining to me in the court?
I don't feel like he was able to take care of himself, let alone the kids.
And who looked after the children while you were at work, when you two were together?
He did.
And did he provide them with food when you were at work?
I would like to assume so, but I don't think so.
And why do you not think so?
Because when I came home, they were always hungry or said they hadn't eaten because they had to wait for me to get home.
And did he provide for their schooling while you were at work?
No,
And why don't you believe so?
because I did all of the schooling.
And did you have any other concerns at all about Mr. Ranger looking after the kids while you were at work when you two were together?
Just the scheduling with them being asleep all day and up all night.
Can you tell me a little bit more about that?
I would get home at 5 in the afternoon sometimes and they were just getting out of bed.
Okay. And did that concern you?
Yeah, I would like them to be on a decent schedule.
Okay. Do you have any, from what you saw, do you know why they were in bed at that time?
Because he liked to stay up all night, so he would keep them up and then they would go to bed really, really early in the morning and sleep all day so that he could sleep all day.
And are you currently working?
Yes.
What is your current position?
I'm an art teacher.
And who looks after the children while you are at work now?
They're at school when I'm at work.
And okay. And to your knowledge, where is Mr. Ranger staying now?
The Amari household, Lynn's house,
And who is Lynn?
his aunt.
And have you ever been in that home yourself?
Yes.
And when was that?
A couple times back in 2021, 2022 time, and then probably 2018, 2019.
And did you ever spend extended time there, like time overnight there?
Yes, we lived there.
And were the kids with you when you spent time there?
Yes.
And from your time that you spent there with the kids, do you believe it's an appropriate place for kids to be staying?
No.
And can you tell me a little bit why?
The situations that happened when we lived there and why we had to leave was not good.
And do you mind expanding just a little bit for me in the court about that?
We had to call the police twice to be able to get our things out of the house because we had a fallout with his aunt.
Okay. And do you believe it would be an appropriate place for the kids to spend overnights now?
No.
Okay. And to your knowledge, is Mr. Ranger currently working?
I believe so.
Okay. And do you have any knowledge about where he's currently working?
Last I heard, it was a key shop.
Okay. And has he provided any support since you two separated, monetarily or any other way?
No.
Okay. And when you two were together, how did you organize your finances?
I worked and he was in charge of finances.
Okay. And when you two separated, did you take over managing the finances for the home?
Yes.
And what sort of things did that include?
Lots of shut-off notices, lots of bills that were not paid or switched names. They were put into my children's names. Just lots of debt.
Okay. And did you have knowledge, excuse me, did you have knowledge of any of those bills or debts before you two separated?
Some of them I had an idea about, but I didn't know it was that extensive, no.
Okay. And have you been able to catch up on the household bills, energy bill, mortgage, things like that since then?
Yes, everything is paid and taken care of, and I have no shut-off notices.
Okay. Just one more reminder about speaking up. And since separation, have you been solely responsible for paying the mortgage and the upkeep related to the home?
Yes.
And has Mr. Ranger provided any support or otherwise regarding mortgage or upkeep of the house?
No.
Okay. And how long have the kids lived in this home?
Since May of 2022.
Okay. And you said that Cherry also lives there. Can you describe what's her relationship to the children?
She is their older sister, and she helps out a lot with them and just helps out with everything. She's great.
And is she your biological daughter?
No, she's Ronnie's daughter.
Okay. And do you have legal guardianship over Cherry?
Yes.
And since around when have you had legal guardianship over her?
August of 2023.
Okay. And she's been staying with you at the house since then and
Yes.
before then as well?
Yes.
And do the kids have any other connections in the community where you're living in now?
Yes, they have friends that live in the neighborhood, and they charity volunteers at Red Cross, and they are part of a Bearcat Blast summer program.
Okay. And can you describe for me in the court just what like a normal day in the life routine for the kids is?
We wake up early in the morning, get ready for school, then we drive to school. They get on the bus from where I work to go to school. Then when we get out of school, we usually make a couple stops on our way home, do homework, make dinner, play outside if it's nice, or play board games or watch a movie and then go to bed.
Okay. And do you have any concerns at all about the effect of reintroducing Mr. Ranger into the children's routine after the long separation that they've had?
Yes.
And can you describe what those concerns are?
It's taken a long time to get them back to a normal schedule where they can function properly. And I think I don't want that upset again and having to work to get that back to where it needs to be.
And when you mention a normal schedule, are you referring to like how their sleep schedule was before?
Yeah, mainly.
Okay. And do you believe that it is in the best interest of the kids to remain in the home that you and them have been living in
Yes.
since 2022?
Yes.
And why is that?
I think it gives them a sense of security and makes them feel safe.
And when the kids were first born, were you working?
Yes.
And was Mr. Ranger working at that time?
No.
And is that the arrangement that you preferred, to be working while he stayed at home?
No.
And why was that the arrangement that you came to then?
Because I had a college degree and could make more money.
Okay. And when you all lived in the same house together, can you describe what your relationship was like to Mr. Ranger?
We were married.
Can you describe what the environment was like in the household?
It was okay sometimes. We walked on eggshells a lot.
Mhm.
Just always trying to make him okay and happy.
And when you say walk on eggshells, can you tell me a little bit more about what you mean by that?
Just being careful what we said so we didn't have to make him angry or upset or disrupt lives.
And did he get angry frequently?
When he was drinking, yes.
And did he drink frequently?
Yes.
And what sort of things would he do when he drank and got angry?
Throw things, break doors, cupboards, yell, scream, pick arguments for no reason.
And did he ever do any of those behaviors while the kids were around?
Yes.
And did he ever do it in front of the kids?
Yes.
And did you ever consider leaving the house because of his behavior?
Yes.
And were you ever prevented from leaving the house?
Yes.
Can you tell me when that happened?
In January of 2023, we tried to leave and he prevented us from doing so by pouring bong water in the car and sitting in it so that we could not leave.
And when you say we, are you referring to you and the kids?
Yes.
Okay. And what was it in January that in particular prompted you to want to leave that time?
He had been drinking and started an argument. I don't even recall what the argument was about at the time. And just was relentless and wouldn't stop. I called the police twice, and on the second time, we were finally allowed to leave and went and stayed with my dad for a couple days.
Okay. And has Mr. Ranger ever been physically violent with you in the past?
Not until March 15th.
And can you tell me in the court a little bit about what happened on March 15th?
We had started arguing. He had been drinking. I was trying to go to sleep because I had to work in the morning. He kept coming down. I told him that I would get up so that he could go to bed because he was laying on the floor complaining that he wanted to go to bed. And then he changed his mind, went upstairs. I went back downstairs and went into my office to sleep on the couch. He kept coming up and down, so I started to record him because I was worried or scared, I don't know. But he found out I was recording him and didn't like it, so he started to come after me. I tried to get out of the room and he went over my back and got on top of my back. I hit my face on the couch. He was elbowing me, trying to get my phone out of my hands. I told him I was going to call the police, and he broke my cell phone case. And then when I got away, I went upstairs, told him I was going to call the police again, and then he went outside into the garage.
Okay. And was he successful in taking the phone away from you?
No.
Okay. And was he arrested that night?
Yes.
And were the kids in the house when this happened?
Yes.
Was he charged with anything following his arrest?
Yes.
Okay. And what were those charges?
Interfering with communication and domestic violence.
And what's the status of that criminal case right now?
It's still pending. We're waiting for a date for trial.
So there's no trial date yet?
Not yet.
Okay. And did you ever file for a personal protection order against Mr. Ranger?
Yes.
And was that order granted?
Yes.
And did he ever violate that order?
Yes, he did.
And as part of the criminal case, did you ever get a no contact order between you and Mr. Ranger?
Yes.
Did he ever violate that?
Yes.
Can you tell me in the court a little bit more about the circumstances of those violations?
He was arrested again June 9th, I believe, of 2023, for driving by the house and then texting my neighbor that he was going to murder all of us and burn my brother-in-law's house down. Then he was arrested when he drove by my brother-in-law's house and the police were there, and then was not released until he got put on tether.
Okay. And what did you do following those instances of him driving by and making that threat?
We started packing up to leave the house. My mom and sisters came over, helped us get stuff around, and we were going to go stay with my dad for a couple nights till we felt safe. And as we were on our way there, we saw him getting arrested.
Okay. And when you say we, are you referring to you and the kids?
Yes.
And so did the kids see him get arrested?
Yes.
And from what you observed when the kids saw that, did you see them be affected by that at all?
I think they were relieved.
And following that, do you have any safety concerns for the kids if they were to spend overnights now with Mr. Ranger?
Yes.
Can you tell me in the court a little bit about what those safety concerns are?
I don't trust him to not drink and be able to take care of them.
Okay. And do you have any other concerns about either your own safety as well if you were to have overnights with the kids?
Not my personal safety, but I just want them to be in a healthy environment, and I don't think where he's staying is a healthy environment.
Okay. And why do you believe it's not a healthy environment for the kids to spend overnights in?
Because they've lived there before and they've seen all the things that have happened, and it wasn't a good situation.
Did they have their own rooms when they were staying where Mr. Ranger is currently staying?
No, we lived in the basement.
And do you have any safety concerns for the kids if Mr. Ranger was to have unsupervised visits with the kids now?
Yes.
And what concerns would those be?
I don't think it's healthy for them to be around him when he can't take care of himself, and I don't trust him.
Okay. And do you have any suggestions for who could supervise the kids if he was to have supervised parenting time?
I would prefer CPS or Family and Child Services.
Okay. And would you be open at all to a family member, either yours or his, to provide supervision?
No.
And why not?
I don't trust anyone in his family. I don't trust him. And as for my family, I don't trust him with my family or.
Okay. And why is it that you don't trust him with your family?
Because of his threats and things that he's made towards my family before.
Okay. And do you believe it's possible at all for you and Mr. Ranger to make joint decisions regarding the well-being of the kid?
No.
Why not?
I feel like it would always be an argument and just not a healthy situation for them.
And do you and Mr. Ranger agree on how the kids should be schooled?
No.
Okay. And do you believe that they should be going to in-person schooling?
Yes.
And from your conversations with him that you've had in the past and when you two live together, do you believe that he wants them to be homeschooled?
I don't know where he stands now, but before, yes.
Okay. And are you and Mr. Ranger able to make joint medical decisions for the kids?
I don't think so, no.
Okay. And why do you not think so?
It was more of a not wanting them to have their vaccinations and things like that they needed for school.
And was it you that didn't want them to have vaccinations?
No.
Was it Mr. Ranger that didn't want them to have vaccinations?
I think it was just more of an inconvenience because Lucy had a reaction when she was younger.
Okay. But you two weren't able to come to a real agreement about that, or?
I don't think it was ever like truly discussed. It was just kind of like, okay, I guess we're not going to do this completely.
Okay. And were you and Mr. Ranger ever to make joint decisions regarding the kids' religious upbringing when you two were together?
No.
Can you tell me a little bit more about that?
It wasn't a topic. He has his beliefs and I have my beliefs, and it just was never a topic.
Okay. And so did you two ever celebrate holidays with the kids or anything like that?
No.
Okay. And were you hoping to raise the kids in any sort of religious upbringing? And
No, not necessarily.
And when you two were together, did Mr. Ranger have any religious upbringing that he wanted to raise the kids in?
Not necessarily.
Okay.
Just a void of religion, I guess.
Okay. And do you believe that it would be harmful to the kids at all if Mr. Ranger was to get parenting time before his criminal sentencing is complete?
Yes.
And why is that? Can you tell me a little bit more?
I think reintroducing him right now before he could possibly go to jail wouldn't be healthy for them, to have him back and then have him taken away again. I don't think that's in their best interest.
Do you think it would have a negative impact on them if he was to spend some time with them, but then be taken away possibly for some time?
Yes.
Okay. And do you believe that there should be any preconditions on Mr. Ranger being awarded parenting time?
Yeah.
And what would those be?
I would love it if he would take a parenting or anger management class.
Okay. And do you believe it's appropriate for Mr. Ranger to have unsupervised parenting time initially?
No.
And why not?
Given the situation, I don't feel like it's in their best interest to be with him alone and feel like scared or like they're going to be manipulated by him.
And would it be following what the CPS safety plan says if he was to have supervised parenting time?
Yes.
Okay. And do you believe it's in the best interest for the children for Mr. Ranger to have overnight parenting time initially?
No.
And why not?
I don't feel like he's capable of doing that or have a good enough living situation for them to be with him.
Okay. And you're referring to the house that he's staying at, which you stayed at before with the kids? Okay. And do you believe it's in the best interest for the kids for you to be awarded sole legal custody of the kids?
Yes.
And can you tell me a little bit more about why?
I've been with them their whole life, and then since March, we have just kind of built a stronger relationship, stronger bond, and become more of a unit than we've ever been before.
And do you believe you can make decisions about their religion and their health and their schooling in their best interest?
Yes.
I'm going to ask a couple of questions about the property involved now.
Okay.
So the house that you and the kids currently live in, who is it titled to?
Me.
And is it just you?
Yes.
And when was the home purchased? Even just a roundabout of the year.
May of 2022.
And is there a mortgage on that house?
Yes.
And in whose name is that mortgage?
Mine.
And is it just your name?
Yes.
And when you two were together, how were those mortgage payments paid?
From me.
Okay. And since you two separated, have you been keeping up with the mortgage?
Yes.
Okay. And you're the only one who's been making payments towards that mortgage?
I did have help for half of a payment from my father.
Okay. And do you have other utilities or upkeep related to the house?
Yes.
Okay. Can you tell me a little bit more about what that is?
Utility bills, internet, yard work stuff that needs to be done. We need a new roof, just upkeep on the house and the utility bills.
Okay. And you've been keeping up with all of that since you separated?
Yes.
Okay. And is there any personal property that you're aware of that you would be able to and willing to give to Mr. Ranger as part of this divorce? Anything that's his in particular?
Yeah, his arcade machines, his bar, his personal belongings. He's got stereo equipment, his motorcycle, things like that.
Mhm. And the arcade machines, can you describe a little bit more, like what are those? Exactly.
They are like full arcade cabinets, like old school, like 80s arcade cabinets.
Like the ones that you'd see at like an arcade bar
Yeah.
or something? Okay. And then can you tell me what's that bar equipment that you referenced?
It's just a big leather face bar with stools
Okay. And where's all that property right now?
in my garage.
Okay. And when you lived together, you said that you were working and he was in charge of covering the bills.
Mhm.
Is that right? Okay. And did he ever tell you that he had missed a bill or was late on a payment?
Yeah, I knew sometimes, yeah.
Okay. And did he ever consult you about paying the bills or paying credit card bills or anything like that?
No.
Okay. And do you, Mr. Ranger, have any debt that was accrued during the marriage?
Yes.
Okay. So can you tell me what those debt accounts are?
I have, there's, I believe, 4 or 5, yeah.
Is-
5 credit cards, I believe, that have not been paid on, that have gone to collections. And then 1 for the car that was repossessed.
Okay. Is there a JP Morgan and Chase card?
Yes.
And is there a Wayfair card?
Yes.
And a Capital One card?
Yes.
And a Menards card?
Yes.
Okay. And the JP Morgan and Chase card that we talked about.
Mhm.
When was that opened?
I have no idea.
Okay. And was it Mr. Ranger who opened the card?
Yes.
Whose name is the card under?
Mine.
Okay. And were you aware that he opened that card and was making purchases under your name when you two were married?
Not at the time that he got them, no.
Okay. When did you become aware?
Probably when we started getting bills for them.
Okay. And was that before or after you two separated?
Before.
Okay. And then for the Wayfair card as well, was that opened in your name
Mm-hmm.
and your name only?
Mm-hmm.
Were you aware when it was opened?
Not when it was opened, no.
Okay. And then when did you become aware of it?
When he bought some furniture and told me about it, but I didn't know that he wasn't paying it.
Okay. And then for the Menards card, were you aware of that one being
Yeah.
opened?
Yes.
Okay. And were there any other instances in the past of Mr. Ranger not paying bills or credit cards?
Yes.
And can you tell me a little bit more about those?
We've we had lots of bills that had shut off notices and he would switch names and of them. Apartments that he would stop paying the rent on and then get kicked out of, things like that.
And the bills that he would switch names on, were those the energy bills?
Yes, the consumer's bill he had in my daughter Lucille's name.
Okay. And when you two separated, did you have to stop that account?
I did. I had to have that switched over into my name. And in doing so, they found 3 other accounts that he had switched names on for properties that we lived in. And I had to pay close to $4,000 to be able to get those accounts back up and running so that I could have power in my house.
Okay. And since catching up on those bills and since you two have separated, have you had any issues keeping up with your bills for the house, utilities, etc.?
No.
Okay. So how do you propose that personal property should be divided in this divorce?
I believe that the kids and I should stay at the house and he should get his personal belongings and his arcades and the bar and his motorcycle, and then whatever car he's driving, and then I should keep my car.
And are you proposing that you would maintain the mortgage and utilities of the house solely?
Yes, by myself.
Okay. And how do you believe the debts that were accrued during the marriage should be divided?
I believe that some of the credit cards that he should take over, and I would take the ones that were used on things for the household.
And so which cards, if you know, were used on things for the household?
The Menards card for sure. The Wayfair card, I believe, was just used for things for the house. And I would be willing to take that one as well.
Okay, but the Capital One and the JP Morgan and Chase, in your knowledge, were not used for those things?
I don't think they were used for things for the house. And when I reached out to them, they could not give me a list of what was purchased on them. So I don't feel like it should be my responsibility.
And did you recently receive a tax refund from the Michigan government for your 2022 taxes?
I did.
And have you been able to cash that?
I have not.
Why not?
Because his name's on it as well.
Okay, and so you would both have to sign it in order to cash it? And so how do you propose that or what's the amount, even just an estimate of the amount is fine?
It's a little over $1,200.
Okay, and how do you propose that check that's in both your names from your taxes when you two are still together should be divided?
I think it would be smart if it was cashed and then put towards some of the debt.
Okay. Well, thank you, Your Honor. I have no further questions for Ms. Ranger.
Okay. Sir, do you have any questions for the plaintiff?
I don't have any questions, no.
Okay. Well, let me, I do have some for you, ma'am. So you have, basically, you're talking in the Menards, it's approximately $3,000, and the Wayfair is about $2,000, so you'd be taking over $5,000 approximately in debt, correct?
If that's what has to be done, then yes.
Well, you said you were going to take that over, so it's not, if that has to be done, you said you're willing to take that.
Out of the 5 cards, and the car payment, that's what I'm willing to take, yes.
Okay. So the JP Morgan is approximately 3,600 and Capital One is 4,100. So that's about $7,700, correct?
Yes.
Now tell me, you have on your property division chart a car that was repossessed.
Yes.
What was the vehicle that was repossessed?
It was a Ford Flex, and we had a loan through Bridgecrest.
Tell me what happened. Why did it get repossessed?
I wasn't able to make the payments on it and keep the house, so I had to choose, and I didn't really like the car or want the car anyways, so
Well, how did it come about that the car was purchased? Did you purchase it? Did he purchase it? Did you jointly purchase it? Whose name was it in?
it was his idea to get it through Carvana. He picked out what he liked, what he wanted, and then had it delivered, and then I signed for it. It was in my name.
And when was that purchased approximately?
I honestly, I'm not 100% sure. I
Well,
think
give me an idea, approximate then.
the summer of 2022.
So for approximately, let's say 6 to 8 months prior to separation, you basically both had access to that vehicle?
Yeah, that was our only vehicle.
You had talked about, for a period of time, you talked about, you were working, during the marriage and he was kind of at home and taking care of the kids, or at least watching the kids. Did the defendant work during the marriage?
He would get a job every once in a while, but he never would keep a job. So for most of the marriage, no, he did not work.
How long, during the marriage, how long was the longest that he maintained employment?
Maybe a couple months.
Why was he not able to keep a job?
I don't know.
Well, did he quit the jobs or did he get fired from the jobs?
He'd quit them.
Did he ever tell you why?
He just would basically say he couldn't do it.
You say in your property chart, you list for him to receive a motorcycle, but then I think when you were testifying, you used the plural, more motorcycles. Are there more than one motorcycle?
No, he just has one.
Okay. And what type of a motorcycle is that?
It's a Harley. That's all I know.
Do you know what size?
Nope.
When did he purchase that?
I don't remember.
Approximately?
Would have been 2017, 2018. I'm not 100% sure. I don't remember.
Do you remember at the time that purchased, do you remember what the cost of it was to purchase that?
I do not. He bought one used, and he rebuilt most of it himself. So it's not the same exact motorcycle that he bought. He's changed a lot of it and done a lot of modifications.
Okay. You don't list any value for that. Do you have any idea how much it's worth?
No.
Since you separated, you said that the defendant attempted to have parenting time back in April of 2023. And you stated that he only had the kids for about 25 minutes and that he's not sought parenting time since then. Has he called or communicated to you to attempt to acquire parenting time?
He is not allowed to contact me. He has a
Okay.
PPO and a no contact order. He did contact me through third party, which is also a violation, but that was how he was able to see them in April through his sister. But he has to go through CPS or through the court to be able to see them per the safety order. So that's something that he would have to take
You
upon
say
himself.
CPS, what, when CPS, again, started a case, did they, is that case ongoing or what's happening with that?
It has been ongoing through all of this until the divorce is finalized and a custody order is made.
When there were various allegations made at some point, did CPS substantiate the allegations?
I think plaintiff is just a little bit unclear what substantiate means.
Okay. Did CPS determine that there was, in fact, a basis for taking action in this matter, and then they continued to oversee or supervise the case?
Yes,
Okay. As opposed to if they would have done an investigation and not found a basis to substantiate, they would have simply dropped it at that point.
okay, yes. They have stayed with an ongoing case with us.
Have you been contacted by CPS in the interim in which defendant has communicated to them that he wanted to have parenting time?
No, the last I talked to our CPS officer, she said that she had not talked to him at all.
You have on your list property, you have some various personal property, your stove, washer, dryer, you want to retain that, is that correct?
I believe those belong in the household, and we have a new stove, and the washer and dryer were gifts to me from my father.
Okay. Just so we get clear, when I'm asking you a question, listen to the question. I'm saying, do you want to keep those? I don't need a narrative of how they came about or what happened. I may go into that, but I was just asking you if you wanted to keep them, and then you went into that. So just answer the question that I asked, please. You have a Coachman camper, you state, that you believe to be about $2,000. Whose name is that?
I believe it's in his name. I'm not sure.
And where is that camper at?
It's currently at a friend's property,
Friend of yours, a friend of his?
a friend of mine.
You said you are an art teacher, is that correct, ma'am?
Yes.
And what is your income in that position?
I probably make 40,000 a year.
I will let you know that, okay, nothing at this point. Have you been in that position as a teacher? Have you been in that position throughout the marriage, or is that something recent?
This is recent. I worked at Hobby Lobby before.
Okay. When did you get the job as the art teacher?
In December.
Of 2023?
Yes.
And before that, you were at Hobby Lobby?
Yes.
Could you tell me during the marriage, just because obviously you have substantial debt and, you know, you've talked about the debt, had either you or the defendant filed bankruptcy during the marriage?
No.
It's fair to say, I'm looking at all of the debt and your testimony that, and I guess it's unfortunate for you, ma'am, but all of the debt as it relates to the Ford Flex, all the credit cards, everything else, it all appears to be in your name, correct?
Yes.
Okay, I don't have anything further. Ms. Redmond, do you have any more questions as a result of the court's inquiry?
No further questions.
Mr. Redinger, I'll give you a chance to, do you, as a result of the court's question, do you have any questions for the plaintiff?
Well, I don't have any questions for the plaintiff specifically, but
Okay. You'll get a chance to speak. Just right now we're dealing with the plaintiff.
I got you.
With that, no questions, Ms. Redmond, any additional evidence?
I would like to call Mr. Ranger as a witness, Your Honor.
Okay,
Thank you. Mr. Ranger, is there anyone else in the room with you currently?
No,
Is there anyone that you've been looking at behind in the camera or making comments at?
no,
And you're currently staying at your aunt's house, is that right?
I am.
And the only room for the kids is in the basement, is that true?
That's not true. No, there's 6 bedrooms here and there's only 3 people living here.
And in the past, when you have stayed there, the kids did stay with you in the basement, is that right?
That is true.
Okay. And you were arrested on March 15th, is that right?
Yes,
And that was the incident, that was after the incident Miss Ranger described, where you attempted to take her phone away from her, jumped on her back. Is that right?
that's not what happened, but I don't know if I should speak on that until I see my court date.
But that's when you were arrested, March
okay,
15th.
Ms. Redmond, I'll instruct the defendant, because you do have a pending criminal case, you have a right to invoke your right against self-incrimination, so you do not have to testify about that. I'm just cautioning you now, sir, because I don't know if Ms. Redmond's going to continue to try to question you about this, but you have that privilege against self-incrimination, but you're going to have to assert that, okay? So if she asks you something and I'm not, let's say, paying attention, I don't want you to answer something that you shouldn't, okay?
Okay, I'd like to invoke my right to remain silent as far as anything
Okay,
involving my criminal case goes.
okay, you have a right to remain silent.
Thank you, Your Honor. Currently, Miss Ranger has both a PPO and a no contact order against you. Is that right?
Yes,
Okay. And you were arrested again in June of 2023 following a violation. Is that right? Is that
yes,
true? Okay. And you were subject to a CPS investigation following the incident on March 15th. Is that true?
yes.
And a safety plan was put into place?
At first, yes.
And the safety plan allows you to have supervised contact with the kids. Is that right?
I was not made aware of that, no.
So CPS didn't tell you that there was a safety plan or that you were allowed to see the kids at all?
No, not at all. Not
And
one time.
have you seen the kids since that March 15th incident?
I've not seen my children in 359 days
Did you see them in April of 2023?
for 45 minutes. Yes. Okay. Excuse me.
Okay. And you haven't provided any monetary support for the kids since you two separated, is that right?
I have a no contact order. I'm not able to.
But you didn't provide any support through friend of the court, through court order, or anything like that? Without contacting Miss Ranger?
I don't have, I didn't have any paperwork, or I don't know. I'm not supposed to have any contact with her. So I don't know how I'm supposed to participate in any sort of monetary or parenting anything. I'm not able to even talk to her.
And you haven't made a payment on the mortgage, utilities, or anything related to the house, is that right?
I'm not able to.
Okay, not even through like an electronic payment where you wouldn't have to interact with Miss Ranger at all?
I'd be more than happy to, but I believe that the mortgage company's been sold over and over. I don't know who to pay. I don't have access to that information.
And you had access to all of Miss Ranger's information when you two were together though, right?
Yes.
Okay. And what personal property at issue in this divorce would you like to be awarded?
Well, I would like to have all my stuff back, but in the paperwork that I was given, it said it was all sold to pay off debt, and it came from you. So as far as I'm aware, the camper was gone, the arcade was gone, everything was gone. In the paperwork that I was sent from you, it said that, yes.
So disregarding that paperwork, that was a property chart, but disregarding that paperwork, from the property that you were aware of when you separated, the property that was all available when you two separated, from that, what would you like to be awarded in the divorce?
I'd like to have all my belongings back, but like I said, I was made to believe that it was all gone, so I didn't plan on making the statement I'm making right now.
And when you say all of your belongings, can you just be a little bit more specific? What belongings would those be?
All my arcade machines, all my stereo equipment, my camper, my motorcycle trailer, just everything that is not hers. That's mine.
Okay, so arcade machines, camper, and a motorcycle trailer, you said?
Yeah.
Can you tell me what is a motorcycle trailer?
It's just it's an old wooden trailer from the 50s with a ramp on it that I got
Okay.
specifically for my motorcycle if it broke down.
And the arcade games, can you tell me, are those the stand-up games that Miss Ranger referenced?
Yes.
And how many of those are there?
I believe there were 6.
6? Okay. And
6 or 7. Yeah. And I had a pinball machine too.
okay. Do you have an estimate of how much each of those would be worth?
Between 500 and between $500 and $2,500.
Okay. And that's each, like, depending on which game it is, or?
Correct.
Okay. And then the camper that we were talking about before, can you tell me what your estimate of the value is?
I believe it's $2,000.
Okay.
Or 1,800. 1,800.
Okay. And are you on the title of that camper?
No, I never got a chance to get to that.
Okay. So is there no title on the camper?
There's a bill of sale.
Bill of sale. Okay. And when was it purchased?
That was purchased in February of 23.
Okay. And then is there an estimate of value for the motorcycle trailer that you mentioned?
And I believe I paid $150 for it.
Okay. Miss Ranger also referenced stereo equipment. Is that something that was in your possession before you two separated?
Yes.
Okay. Can you tell me what equipment that is? Is it like a speaker? Is it
Subwoofers and amplifiers.
okay. And do you have an estimate of the value of that?
Roughly 2,000.
Okay. And the motorcycle as well. Can you tell me what type of motorcycle it is?
It's a 2001 Harley Davidson Sportster 883.
Okay. And when was that purchased?
And that was purchased in February of 2015.
Okay. And where is that motorcycle now?
It's at my parents' house.
Okay. And Miss Ranger referenced that maybe some parts have been changed or you've done work on it. So how much did you pay for it when you purchased it?
I paid $3,000 for it.
Okay. And do you have an estimate of how much it is worth now?
Probably about the same.
Okay.
I don't know. It's I mean, I'd have to look it up. Could be more, could be less. I don't know.
And then the bar that Miss Ranger referenced, the like long bar that's in the garage, do you have an estimate of how much that is worth?
With that, the stools, I would say right around $600.
Okay. Okay. And then are you currently working?
I am.
And where is it that you're working?
I work for AZ Key Shop. I'm a locksmith.
Okay. And how much do you make per hour?
I make 16 per hour.
Per hour. And then how many hours do you work per week?
46.
Do you get any overtime?
6 hours.
Okay. And does your pay increase with that overtime?
Well, yeah, time and a half.
Okay. Time and a half. And sorry, is that 6 hours per week that you usually do overtime, time and a half?
Yeah.
Okay. And then do you have insurance provided by your work?
No.
Okay. No further questions, Your Honor. Thank you.
Thank you. Sir, I think you answered that. Oh, you mentioned on you said arcade cabinets and then you said pinball machines, correct?
I have one singular pinball machine.
Oh, one pinball, okay. Well, just so I get an idea, because you have obviously 5 arcade, 1 pinball, all combined, how much would you say that all 6 of those are worth?
I'd say roughly between, I don't know, 8 and 15,000.
Well, that's
Those
a big,
arcade, well, those arcade machines are heavily modified with computers and fair market value for what I have would be right about that with all the modifications that I've made to them, upgrades.
okay.
If I were to sell, if I were to just sell everything in a lot, that's what I would probably ask for about 12 grand.
Sir, you can take this opportunity to tell me whatever you'd like to tell me.
Okay. Well, for one thing, I was told by CPS about 6 months ago that this case was closed. And also, I was not made aware that I could ask for parenting time. All I was told to do was go in there and take drug tests and answer their questions. I chose after a while to not participate. And then when I called back to find out what was going on with that case or when I could see my kids, they told me that the case has been closed or was about to be closed. So I'm not too sure about that. I'm not too sure why like everybody thinks I'm just drunk, but I work full time. I work 46 hours a week and I have a perfectly fine home here. I don't see why I should have to not see my children and pay child support. I haven't seen them in almost a year. As far as I'm concerned, I had to sell my motorcycle to get out of jail. So I sold it to my parents, and I'm driving their car. I have 2 bins of clothing that I have in the basement of my aunt's house that I'm renting. I really don't have, I'm more than able to help support and pay bills, and I'd be more than willing to. But I just have not been able to with a no contact order. I don't have information. I don't have account numbers. Everything was on the computer at home. If she needs any sort of help, I'd be more than willing to help. But I would also like to see my children at some point, regardless of if it's now or after this pending case. I don't think that's very fair. A lot of what she is claiming, I find to be not true. I don't really know if it's necessary for me to go into detail, but I don't know. I guess that's all I have to say.
Any other cross-examination, Ms. Redmond?
Just briefly, Your Honor. And so, Mr. Ranger, you said you're working full-time now, but you weren't when you two were together, isn't that right?
I worked up until I did skip jobs a lot, but that's because we moved around a lot. But I did work up until 2015 when she had Oliver.
But for most of the period of the marriage, she was the one that was working and you were not working.
Half and half. I worked, we had Lucille when we were in Grand Rapids, and I was working all the way up until, for our marriage, all the way up until then. And then we moved around a lot. I was working when we moved to Bellevue. Yes, I worked at Denso. When I was in Grand Rapids, I worked at the, I think it was GRFD. And when we moved, like sure, I did it in increments, 3-4 month increments, but all in between those times, I always found side work. And I can pull up references if you need.
And since you two lived in Battle Creek since around May of 2022, did you have a job when you were staying in that house that Ms. Ranger?
In that house? No, I did not. But in the first, I believe in the first 8 months of us living there, we were getting the child tax credit, and that was paying the mortgage.
And you said that you chose not to go along with CPS's recommendations. Can you tell us why?
Because it's voluntary.
And so why
And
did you
I felt there was no reason. I wasn't made aware of what I was being investigated for. I didn't know. They just slapped a paper in front of me and told me to sign the safety plan. And then when I signed it, I called an attorney, and the attorney told me to call and revoke it and not to participate in it. I was advised by an attorney to not participate in CPS proceedings.
So you were advised to not follow along with CPS recommendations for, I believe you said it was drug testing?
You know what? I did that anyways.
Then what were the recommendations that you decided you weren't
The
going
safety
to
plan that they wanted me to sign. He told me to revoke my safety plan signature, which I did, but I did continually go down there and try and show them that, like, I'm not doing drugs. I did it for, I probably went down there 7 or 8 times passing drug tests.
But
and then after a while, the caseworker switched over. And then when I started talking to the new one, couldn't really much get a hold of her.
Mhm.
So finally I had to call everybody just to get a hold of that one person. I don't remember what her name was. And then when I finally got a hold of her, I was told that the case was going to be closed within a month or something like that. And I had not heard anything afterwards.
So, the safety plan that was originally put in place after the March 15th incident, you revoked your signature, and so you didn't sign on to that safety plan. Is that right? That's what I'm hearing?
Yes.
Okay, and you believe that it was, that the CPS recommendations were, that you didn't need to follow through with it, that it was okay?
My attorney advised me to not.
Okay. No further questions, Your Honor.
Okay. Sir, when you work your overtime, you said you work 6 hours overtime.
Yes, sir.
When do you usually work that? Is that like on a Saturday, or is it you work later in the evening? What's the situation?
I work 9 to 5 Monday through Friday, and I work 9 to 3 on Saturday, with an option to work on Sunday if I want more overtime, but I usually don't.
Is that pretty much every week that you work Saturday 9 to 3?
Yes, sir.
Okay. Anything else you'd like me to be aware of, sir?
The house that I'm residing in has been in the family for over 50 years. There's plenty of rooms here. Like I said, it's a 6-bedroom home, and we only use, 3 of the bedrooms. So, I believe, and we're in the Lakeview area. We're, and off of Morningside. It's not a bad neighborhood at all. It's not like I live in, shambles or anything. We have a very nice home here. And, I feel like the kids would be more than safe here, and they've been here before. We lived here for a year, so they'd be used to the place already. I'm working full time, so I'm not up all night drinking like she says I was, and I've been at this job for almost a year now. So I know she's not aware of these things, but I don't find there to be any reason why I can't see my children. I don't think it's fair. And I'm not able to reach out to her in order to get or to ask. I thought the CPS case was over, so I'm just sitting here in limbo, waiting. I don't know. I guess I'm waiting to hear what you have to say about it. Excuse me.
Okay.
I-
Anything else, sir?
No, Your Honor.
Ms. Redmond, anything as a result of my questions or any statements by the defendant?
Not at this time, Your Honor, no.
Okay. So, Ms. Redmond, at this time, do you rest?
Yes, I do, Your Honor.
Mr. Renninger, as a result of Ms. Redmond resting, what that means is she's concluded her case.
Okay.
You have a right now at this point, because you did reserve on your opening statement, you can make an opening statement, then you can proceed with any additional proofs. I know it's kind of a combination because you did testify when she called you for cross, but you have a right to present anything else at this time if you wish to do so.
Well, as far as the credit card debt goes, I have receipts for everything. As far as the worth of all of my belongings, I have receipts for all of those. I don't really have much else to say about anything. No.
Any other proofs, sir?
No, Your Honor.
Okay, thank you. You rest as well?
Do.
Okay, Ms. Redmond, you can make any closing argument.
Thank you, Your Honor. In closing, Ms. Ranger is requesting that this divorce be granted and that she's awarded sole legal and physical custody of the 2 minor children. She requests that Mr. Ranger's parenting time is suspended until the completion of his criminal sentencing to avoid harming the children's reestablishment of the parent-child bond by initiating parenting time and then having it potentially stopped after his sentencing. She asks that before parenting time is reinstated, that Mr. Ranger complete an anger management or parenting course or something of the equivalent nature. She asks that any initial parenting time be supervised through family and children's services in order to help maintain and establish a bond with Mr. Ranger, whom the kids have not seen for almost a year now. She's asking that child support be ordered according to the Michigan child support formula, and that she remains in possession of the house that she and the children live in, which is titled to her, and which she has been making payments on the mortgage and utilities on solely for the duration of the marriage and since separation. She requests that each party maintains the vehicles in their possession, including Mr. Ranger's motorcycle, which he valued at around $3,000. She requests that Ms. Ranger receive his personal property, including the property that he identified, the arcade games, which he valued at around $12,000 or $8,000 to $15,000, depending on where it is sold, including the bar, the pinball machine, and the other various personal property that is still remaining in the household. She asks that Mr. Ranger assume the debts that he incurred in her name without her knowledge or consent during the marriage, which would include the JP Morgan and Chase debt, Capital One debt. And she requests that Mr. Ranger sign the check that she received for a tax refund, the Michigan 2022 tax refund, and that the money from the check be applied to one of the debts that was incurred during the marriage. And she finally requests that her former surname be restored.
Thank you. Mr. Renninger, you have an opportunity now to give a closing argument if you wish to do so.
Closing argument. I don't believe that she should get everything and I should get nothing and no parenting time. And I have to pay child support and incur debt that we both incur.
Thank you. But I do, it's now 9:48 a.m. What I'm going to do is put you both in the waiting room. I have to go back and look at, again, the testimony, property division charts, and come up with a calculation as it relates to the assets and debt. So I'm gonna go do that now, and then we'll resume. I want to say it's probably 15 minutes, but I'll say 15 is usually a half hour. So I'll bring you back in at about 10:30, and then I'll be able to give you my ruling at that time. Welcome back. Court has had opportunity to review all the notes and the case, the property division chart, and been able to come up with, again, a resolution of those particular issues. I'll first note to the parties in this matter that credibility is often is always a consideration in every case. Oftentimes, the parties will allege that the other party or their witnesses have not been truthful or lying. That wasn't the case here. No one's alleged that. Court has found there's some brief inconsistencies in testimony, but that's something that's normal. And those conflicts in testimony may occur as a result of a witness's background, a perception, bias, understanding, misunderstanding, or simply a mistake. When the consistencies occur, the court attempts to determine and reconcile those by looking at other evidence and other testimony. And in this matter, as stated, there were some inconsistencies, but they were, again, nominal. When it relates to property issues, a property division need not be mathematically equal, but it must be equitable pursuant to MCL 552.17. An equitable division is one that is roughly congruent, but again, not always to a mathematical certainty. There's no exhaustive list of factors the court must consider to determine what is equitable, but in the case of Sands v. Sands, the Supreme Court held that the court must use its discretion and consider all the circumstances. They do provide a list, but it is not an exhaustive list as to what the court will consider, and the court has done that in this case. First, the court will state that the court will first find that the testimony does establish that there has been a breakdown of the marital relationship, and the court will grant the divorce in this case. The parties did purchase during the marriage the real property at 730, and that property, based upon the plaintiff's property division chart, is have an equity of $15,000. Court will note that the defendant did not file a property division chart, and pursuant to the terms of the case scheduling order dated 11/1/2023, and I quote, "If one party fails to file a chart, the court will use the filing party's chart to determine property and its value," end quote. I've done that in this case, and that's how I've come up with the $15,000 equity. The court will note that the plaintiff has been in that home. She has been since the parties separated, approximately March 15th of 2023. She's been in the home, been solely responsible for the payments on that and the utilities, upkeep, etc. The court will again award to the plaintiff the real property. Next, we get to personal property. The plaintiff has stated she desires to have the 2010 Ford at a value of $3,000, the stove, washer, and dryer. Court has put on $400. She had a range of $300 to $500, so the court is awarding that property to her. The defendant has stated he desires to receive the 6 arcade cabinets and the pinball machine, which he values at approximately $12,000. The court is going to award that to the defendant. Court will further award to him the 2001 Harley-Davidson Sportster, which he states to have a value of $3,000. The court will award that as well. The court will award to him the motorcycle trailer, stereo equipment, and the bar stools in this particular matter. When I do this and I look at the values that I've taken from the testimony and from the plaintiff's property division chart, there's just a matter of a nominal amount of difference of a few $100s. So the court will believe that that is negligible and will disregard any difference. And the court will state that the defendant can acquire his personal property by having a third party pick it up within 30 days of today's date. And if he is not able to arrange a time, or the third party is not able to arrange a time with the plaintiff, that the exchange shall occur on March 30th, 2024 at 4:00 noon. So again, if it can be arranged at a different time, that's fine. But if it can't, then it will occur on the March 30th, 2024 time at noon. The court will, in this matter, order next the payment of debts. In this case, the parties have a deficiency on a repossessed Ford Flex vehicle. The court will order that each party is responsible for 1/2 of that deficiency. And the court will state if the creditor attempts to and is successful in collecting against the party, then the party with whom the amount is collected would provide the other party with proof of payment and will be reimbursed for up to the 1/2 amount that, well, any amount over the 1/2 that they paid. And that would be accomplished through Attorney Redmond's office, not through the parties directly because they have no contact. There's also a number of debts, the Amazon debt of $345, Capital One debt of $4,178.10, the Wayfair debt of $1,918, Chase Morgan, or the JP Morgan Chase of $3,645, and the Menards debt of $2,963. The total debts on that total $3,049.10. There's been testimony that this amount was incurred during the marriage. There's been testimony that the defendant took it out, but it was taken out in the plaintiff's name, so she had to sign for those. So she clearly was aware that there was some debt in this particular matter, although she may not know exactly what the individual amounts were. The court will determine that, again, this is all marital debt. 1/2 of that is $6,524.55. Again, as with the deficiency on the vehicle, the court will leave it up to the parties to pay that. And if the creditor goes after a party, then again, any amounts that they pay above and beyond their 1/2 or the $65,24.55 would be reimbursed to them by the other party. And that would again be accomplished through Attorney Redmond's office. What court will order is that the parties would each execute the tax refund check, that they would do that in Attorney Redmond's office, that amount would then be paid by the plaintiff towards the bills that I've identified above. and she will provide proof of payment through Attorney Redmond's office, who will then provide proof of payment to the defendant. Again, any amounts that would paid from the refund check, that would diminish, again, each party's respective one half share, or the one half of $6,524.55. So that would, the amount paid on that, whatever credit card it's paid on or how it's paid, would diminish the one half. The court would also order that the Coachman camper would be sold, that the proceeds would likewise be paid towards the marital debt that the court's identified. And again, that would be accomplished by the plaintiff. She would provide proof of payment through Ms. Redmond's office, who would then provide that to the defendant. And any amounts, because we don't know how much that would be sold for, or would generate, that amount likewise would go to reduce the one half of the marital debt owed by each party. The next thing the court needs to decide in this matter is custody. Custody is provided for in the statute under MCL 722.21 at sec. In this matter, the court's first responsibility in any case is to determine whether an established custodial environment exists. An established custodial environment exists if over an appreciable period of time, the children naturally look to the custodian in that environment for guidance, discipline, necessities of life, and parental comfort. The statute provides that the age of the child, the physical environment, the inclination of the custodian, and the child as to the permanency of the relationship shall be considered. In this particular matter, the court is not concerned about the reason behind how the established custodial environment came to exist, but the court does determine whether, in fact, it does exist. If, in fact, an established custodial environment exists, then the burden is on the party challenging the established custodial environment, and that is done. The legislature has determined that that is the burden of proof by clear and convincing evidence, and that is done to minimize the prospect of unwarranted or disruptive change in custody and erect barriers against removing the children from the established custodial environment, except in the most compelling cases. Court will note under the applicable statute in this matter that it does provide that the court needs to, again, look at the best interest of the child test as contained under the Child Custody Act. And that's MCL 722.23 in this particular case. The court will note that for the party's edification, that the burden by clear and convincing evidence, again, requires that clear and convincing evidence is evidence which would produce in the mind of the trier of fact a firm belief or conviction as to the allegations sought to be established. Evidence so clear, direct, weighty, and convincing as to enable the fact finder to come to a clear conviction without hesitancy of the truth of the matter asserted. In this particular matter, I'll go through, again, those issues as it relates to the established custodial environment. In this case, the court will note that the parties separated back on March 15, 2023. Since that time, the defendant only had involvement with the children for approximately 25 minutes on April 4th, 2023. Court will note the testimony shows the defendant has not sought parenting time during that approximate year, well, now year period. That the defendant testified he was not aware that he could get parenting time. He thought that he wasn't because first he was not able to communicate with the plaintiff because of the personal protective order as well as the no contact order. The court would state those orders still remain in effect, Mr. Renninger, but I will let you know you have a right to file any motion seeking any relief from the court. You could have done that at any time in the last year if you wish to do so, but you had not done so. And I understand you didn't believe that you had the ability to, but I'll let you know now, you have a right at any point to petition the court, and you could have done that previously. You did not. So the court will note that because of that, again, the children had not been at all in your care. Under the best interest of the child test, the court has to go through 12 factors. The first factor is the love, affection, emotional ties existing between the parties involved and the children. Typically, it's who are the children bonded to? The court looks at, again, the day-to-day upbringing of the children. Who do the children go to when they have issues, when they have problems, etc. In this case, again, those responsibilities have pretty much been abdicated to the plaintiff. The court's not questioning the love, affection, and other emotional ties that exist between the defendant and the children, again, prior to the separation. But again, the court has to look at what is happening currently at the time of this trial in this case. As a result, the court does believe that those bonds and the love, affection, emotional ties does exist between the plaintiff and the children, and that in fact outweighs any bond that may have existed prior to the separation of the parties. The next factor is the capacity and disposition of the parties involved to provide the children with love, affection, guidance, continuation, the education, raising the children in a particular religion or creed. In this matter, there's been very little testimony about raising the children in any particular religion. The plaintiff did testify that it was not a topic that the parties discussed, and that really that they were not raised in any particular religion, so the court will not consider that. Capacity and disposition are two different things. Capacity is whether the people have the ability to, and disposition is whether they follow through with that. And in this case, the defendant could have, again, through filing a petition with the court. He was not aware of that, and he didn't. So the court, at least at this point, will determine that he did not exercise the disposition during the pendency of this matter. The testimony is also in this case that the children had previously been in homeschooling, and that the plaintiff was the one responsible for the homeschooling of the children. She also, back in April of 2023, placed the children into public schools and in-person schools, and she said that the testimony was that children have adapted well to in-person. They have excelled, they have friends, they appear to be happier in this matter, and that they are involved in their schooling. As a result, the court will find that this factor does weigh in favor of the plaintiff mother. Next factor is the capacity and disposition of the parties involved to provide the children with food, clothing, medical care, and other remedial care recognized or permitted under the laws of the state in place of medical care and other material needs. The testimony of both the plaintiff and the defendant is that in the ensuing year in this matter since the separation, the defendant has not provided any financial support for the minor children. And also the court will note that it is the plaintiff that has provided all of this care during the last year when again, the defendant was non-existent. As a result, the court will find that this factor does favor plaintiff mother. Next factor is the length of time the children have lived in a stable, satisfactory environment and the desirability of maintaining continuity. Clearly, the children have been in the home of the plaintiff during the year since the separation. Again, the children are younger. Lucille is 11, Oliver is 8. The court notes that as children are younger, the time has a different meaning to children, is different. That as children are younger, that children will sometimes make statements that something happened, and they'll say, well, it happened a long time ago. Well, it might have been 3 months or it might have been 6 months, but the time is different to them because they have obviously a shorter life cycle. And as a result, what is happened more recent is more prominent with the children. And as a result, the court will find that the children are in a stable, satisfactory environment and will weigh this factor in favor of plaintiff mother. Next factor is the permanency of the family unit, the existing or proposed custodial home or homes. There's been no testimony by either party that there's a change in the family unit in their respective homes, so the court will not weigh that factor in favor of either party. Next factor is the moral fitness of the parties. Again, the court can take into consideration any violent behavior, drinking problems, etc. In this matter, there's been testimony by the plaintiff that, again, the defendant had substantial issues with alcohol, that he would drink to excess, that he would get angry, that he would break things, that she had concerns for the children when this happened. The defendant did not dispute that, state that it was not to the extent that the plaintiff testified. The court will find that this factor does weigh slightly in favor of the plaintiff mother. Next factor is the physical and mental health of the parties involved. There's been no testimony about any mental health issues by either party or physical health issues, so the court will not weigh that in favor of either of the parties in this matter. Next factor is the homeschool and community record of the children. In this matter, the court will note that, again, the children are in the plaintiff's home, that again, in the last at least year, that they've been solely in the schooling, initially a homeschooling with the plaintiff, then in the in-person schooling with the plaintiff. And again, she testified that they're excelling, they're doing well, and that she did testify, I think, that the children also volunteered for Red Cross, and so there was some community involvement. The court will weigh this factor in favor of the plaintiff mother. Next factor is the reasonable preference of the children. If the court considers the children to be of sufficient age to express a preference, the court did have an opportunity to interview the children, and they did offer a preference, which the court is considering in this matter. Next factor is the willingness and ability of each of the parents to facilitate and encourage a close continued parent-child relationship with the other parent. In this matter, I'll note that, again, there's been very little testimony concerning this factor. It doesn't, obviously the defendant has not had the ability to, because the children haven't been in his care, to facilitate. And the court will note that, again, the plaintiff has not taken any action to facilitate a relationship between the defendant and the children. She could have done through a third party, through CPS. There's a lot that she could have done in this particular matter to, again, facilitate that relationship, and she did not do so. The court will weigh this factor slightly in favor of the defendant father. Next factor is domestic violence, regardless of whether the violence was directed against or witnessed by the children. The plaintiff testified that, in fact, there was back on March 15, 2023, at the time that the parties separated, that there was an instance of domestic violence, that, in fact, again, the defendant was intoxicated, that, again, that he had was throwing things, that he had assaulted her, that he had attempted to get her cell phone as he went over her back to do so, that the cell phone case was broken, that the defendant was arrested and charged with domestic violence and interfering with a communication device, for which that action is still pending in this matter. As a result, the court will determine, regardless of how that criminal case turns out, the court will note that, again, that she acquired a personal protective order, that he was arrested either on the violation of the personal protective order or the no contact order in June of 2023, for which he was arrested at that time. The court will find that this factor does favor the plaintiff mother. Any other factors that the court considers to be relevant in this matter, the court does. Apparently, there is another child in the home of the plaintiff, which is a half sibling with, I think, well, maybe it's not a half sibling, but another child in the home with whom the children have a relationship. So the court is taking that into consideration in this matter. In view of the established custodial environment in the home of the plaintiff, she need only establish by a preponderance of evidence that it's in the best interest of the minor children to remain in her care. The court finds, based upon going through the factors, that she has established by clear and convincing evidence and overwhelming evidence that in fact it remains to be in the best interest of the minor children to remain in her care. The defendant has not established the burden of clear and convincing evidence, and court find that the defendant has not even met the preponderance of evidence in this matter, and as a result, the court will grant to the plaintiff sole legal and sole physical custody. That, however, does not address all of the issues that the court has to consider. When that happens, the court has to consider, again, parenting time pursuant to MCL 722.27A. Court will note that it is presumed by the statute that the best interest of the children is to have a strong relationship with both parents. And as a result, the court will go through the factors under the 722.27A1. We'll evaluate the best interest as I have previously under, again, custody, but I'll look at the following factors that the court has to look at. First, special circumstances or needs of the children. There are no special circumstances or need that have been presented in this particular case. Next factor is whether children less than one. That is not applicable either, so the court will not consider. Next factor is the likelihood of abuse or neglect of a child during parenting time. There's been testimony of the plaintiff that she is concerned about the well-being of the children, but there's not been any identification as to what that is, other than that there was a prior CPS referral that had to do from the incident on March 15, 2023. The next factor is likelihood of abuse or of a parent during the exercise of parenting time. We've had no testimony of that. In this case, there's a personal protective order in place as well as a no contact, so the court is not concerned about that occurring. The next factor is the inconvenience or burdensome impact of the travel on the children. Parties reside in the same community, so that is not a problem. The next factor is whether the parent is reasonably expected to exercise ordered parenting time. There's not been ordered parenting time, so the court will not hold that against the defendant that he's not exercised that. Next factor is whether parents frequently failed to exercise parenting time. Court will note that he has not exercised it, but he as a basis, he was not aware that he was entitled to it. But again, there was no ordered parenting time, so the court will take that in consideration. Next factor is threatened or actual detention of the children. There's been no testimony about that. And other relevant factors. The other relevant factors the court will consider is obviously the length of time that the children have not had any contact with the defendant. And as stated at their younger age, that does have a greater impact upon them than if they were older in this particular matter. However, the court, when I weigh all of the factors, as well as the factors under the Child Custody Act, the court does believe, pursuant to the statutory basis, that it is in the best interest of the children to have a strong relationship with both parents, that some parenting time should be awarded in this particular matter. What the court is going to do is the court is going to award to the defendant parenting time, and that parenting time will be in alternating weekends, commencing the weekend of March 16, 2024. The court will grant on an initial basis, because there has to be a reintegration with the children because they have not had time with him. The court is going to grant to him alternating weekend parenting time on Saturday from 4:00 p.m. because he states he works Saturday from 9 to 3, from 4:00 p.m. until 8:00 p.m. And then on the alternating weekends on Sunday, they'll have parenting time from 12:00 noon to 4:00 p.m. The court will also award to him every Wednesday parenting time for up to 4 hours from after he gets out of work until 8:00 p.m. He stated and testified he works until 5. So if he's not able to get the children until 5:30, that he would then have them from 5:30 up until 8:30 each and every Wednesday. The court will order that the defendant not consume any alcoholic or any alcohol or drugs during the parenting time. And the court will order that this parenting time schedule would continue for 9 months from today's date, after which time the court would review it upon petition by the defendant. Court will order that the children shall be picked up by a third party familiar with the children, so it could be a relative of the plaintiff. He's responsible to have them picked up at the plaintiff's home. That be someone familiar with them, and that they would in fact be picked up and returned at the times that the court states. So 4 o'clock on Saturday to 8 o'clock p.m., Sunday from noon to 4, and Wednesday from when he's available after work up until 8 o'clock p.m. So in fact, the court will change what I said about the time, being the fact that he is not picking the children up on the Wednesdays, that it would be somebody else. The court will allow him to have the children from 5 o'clock p.m. on Wednesday to 8 o'clock p.m. on Wednesday. That way, therefore, once he gets home from work after 5, he'll be able to have the children in his care, and we don't have any confusion with, well, if he has to work late or if he gets off earlier or anything of that particular matter. The court will set support in this matter pursuant to the Michigan Child Support Formula, with the plaintiff making $40,000 per year, the defendant making $16 per hour full-time, plus 6 hours per week at time and a half. And the court would make that support effective today's date. With that, I believe that addresses all of the issues the court was required to address today. Ms. Redmond, is there anything else that you believe that the court has failed to address or needs to address before we conclude?
Just that her surname can be restored as well. And that's it, Your Honor.
Excuse me?
Just that her surname can be restored as well.
Sure. Yeah, she had asked for that. That's fine. You can include that in the judgment. The court will ask that Ms. Redmond, you prepare the judgment of divorce as well as the uniform child support order in this matter. Mr. Renninger, is there anything you believe the court needs to address or has failed to address before we conclude?
Yeah. So for the custody, Saturdays are optional for me as far as work goes. If I need to take the day off, I can.
Okay.
So
Well,
maybe if it's every.
What I'm doing is, that's why I made it on Saturday from 4 p.m. to 8 p.m. So you can work every Saturday and still have your 4 hours, or Sunday from noon to 4. Sunday from noon to 4. So you get that time on Saturday and on Sunday.
Okay. Okay. Yeah. I was just gonna, sorry, I don't mean to interrupt.
No, that's fine. Just different hours. I did it to accommodate your schedule so that you would be able to get that time with the children.
Okay. I guess that's what I get to deal with. I'll take
Okay.
it. I'll take whatever I can get.
Okay, Miss Redmond will, in fact, prepare that judgment. UCSO, she'll need to submit that to the front of the court for their approval. And then once she gets the approval, she can submit that to the court. So as long as that judgment is consistent with what the court ruled, Mr. Renninger, you don't have anything you need to do. You don't need to object or anything like that. If, for instance, she does something in there that's different than what the court's ruled, you have a right to object and say, I'm objecting because she didn't give me, the alternating weekends or every Wednesday or whatever it might be, that in fact, you have a right to object to that. She will include with the child support order, there'll be a calculation. That'll be a breakdown based upon what I've ordered as taking into consideration the income. Okay?
Yes, Your Honor.
With that, the court will conclude this matter at 11:04 a.m. You're free to go. Best of luck to both of you. I hope everything works out, and I hope you have a good day. So,
Thank you, Your Honor.